welcome again to our third of a four-part series on the collaborative practice of law. Today's topic is the how-tos of collaborative law. And at this time, I'd like to go ahead and turn the presentation over to our panelists.
Thank you, Eileen. I'm Frances Nolan. I'm here with Brian Turner, Virginia Miller, and Steve Gregory. We're happy to join you, and we really are hoping that people will have questions today because we are getting to sort of the summary part of this series, and we're really most interested in knowing what information you guys have not yet felt like you've gotten, or questions that have developed as you've been listening to this series. Let's just start with a summary of what collaborative law is. Steve, I'm gonna surrender that to you.
This is, if you're following the slides, this is slide 5, and of course we can all read it, but I think I'd kind of like to skip to the last part of that slide, because obviously collaborative law is voluntary and consensual. Those two seem to be essentially the same thing, but an important piece of this is that collaborative law requires informed consent. And, not every kind of law practice we do engage in requires informed consent. And my view of this piece of collaborative law is that informed consent is a bit of a misnomer. And I think all of the collaborative law practitioners would agree here on the panel and elsewhere that merely telling the clients about the collaborative law process is really not enough. And in our practices, when we explain collaborative law to folks who are about to engage in the process, we need to make sure they understand it, not just have been informed about it. So I prefer to really think of it as understanding consent or knowing consent. And as you all know, I think by this point, collaborative law begins with a collaborative participation agreement. You don't really have a collaborative law case unless you have that agreement in place. But that document is something that we go over with the clients in some detail and make sure they understand it and make sure they reflect to us their full understanding of what they are undertaking. Part of the reason for this is that collaborative law, unlike some other kinds of dispute resolution processes, requires a lot more, not only commitment, but more participation by the clients. For example, at the end of every meeting, as you know, we have a series of meetings, each of which has an agenda of things that we're trying to accomplish at that particular meeting. But often, nearly always, at the end of every meeting, the clients have homework to do. They need to go and find certain kinds of documents, perhaps, or they need to find out what an apartment is going to cost them, or it's really nuts and bolts stuff, and they have to participate in that. So clients at the very beginning of the collaborative process need to understand that, because if they don't, they're going to see that they're going to have to do more work themselves than maybe is normal for clients and other kinds of legal undertakings.
It's interesting that you mentioned that, because yesterday when I was talking to a potential new client about collaborative process, what I said to her was, I said, what you need to be aware of is that collaborative is going to require a lot of you. And in fact, there have been people engaged in collaborative process who have turned to the collaborative professionals and said, if we're going to work this hard, why didn't we just stay married? Mm-hmm. And I said, so you need to be aware that we are going to be calling upon you to act from your highest and best selves, to avoid triggers, to work very hard to listen and hear and respond and communicate in an effective way. And I said, the goal of the process is for the team to assist you in accomplishing that. And I think that there are lots and lots of cases in which parties are not going to be able to effectively do that once the team is disassembled. But that with the help of the team, the hope is that they can.
And we've had cases where we've gotten into them and one party or the other, or in some cases even both, have come to us at different points and said, I don't know that I can do this. That, I can think of, cases where definitely at least one party has basically shut down mid-process, and that's where the coaches come in and we all kind of catch our breath and regroup and get them back to understanding that this is their case, this is their outcome, they need to have a vested interest. But this is where I think what Steve was saying about, the title informed consent may not be the best title, because it's hard to get clients to understand on the front end, what
they've never done.
Yeah. You've not communicated in a family law situation. You may not have communicated well with your spouse. You may not have been able to say, identify and address your needs. And we're now asking you to do that. You're doing it with the help of some well-trained professionals, but they have to understand going in clearly this is what we're getting into, and it's not, hey, I'm going to hand this off to my lawyer, and when my lawyer tells me to do A, B, or C, I'm going to do that.
It's a good point you make about communication, Brian, because teaching the clients to communicate with each other during the collaborative process is a big part of what collaborative lawyers have to do, and identifying the communication skills and needs of clients. Sometimes one or both people involved in the collaborative process, one or both of the clients, may have some difficulty expressing emotions, and that may be one of the problems that they had before. And sometimes they may have some difficulty expressing their needs. Again, that may be associated with the difficulty they came to us with. But they have to be coached and encouraged to do that, not only so that the collaborative process can work, but so also that maybe they can learn some skills that they can take away from the process.
I think we're just going to summarize the roles of the team members. I think this was what we kind of went into more depth about at the last webinar. Right. And by the way, the fourth webinar will be a more detailed discussion of informed consent.
Okay. So I'm Virginia Miller, and I think the next slide is discussing again and going back over the roles of the team members. First, the mental health professional, we call them coaches in the collaborative process. And they are there to assist the parties and the lawyers sometimes, a lot of times maybe, in being able to communicate well, and also sometimes the coaches might have a mental health professional who assists the parties in a meeting with determining custodial and visitation arrangements, that type of thing. So you don't need a full meeting necessarily with the parties and the lawyers in order to do that type of work on the custodial time. Not that you can't have a full meeting, but that's part of what the mental health professional can be there for. I think last time, and just as a refresher, last time we talked a little bit about having what we call a one coach versus a two coach model. Here in Birmingham, the Jefferson County metro area, we've been known to use one coach and two coach, just depending on what the situation is. However, there are some other places in the United States where they would be aghast if you didn't have two coaches, or they think it's funny to have two coaches. So it's kind of what the practice groups have gotten used to and what they do. Let's see. Financial neutral.
Let's just make sure we say mental health people are not therapists in this in this role. They're not acting as therapists. That's right. Why we call them coaches.
Right. That's exactly right. Sorry, I skipped over that. I started thinking about the one coach and two coach model, but that's exactly right. They're not there to be your therapist. Some people think that they can use their therapist when they come into the collaborative process as their coach. You need to keep that separate. Your client, when they come into the collaborative process, they need to keep their therapist as their therapist, and they need to have a different individual to be their coach.
And one thing that I think is, since we were talking about the nuts and bolts of how we do this, going into figuring out who these team members are going to be, that in every case that I've been in has been, the first conversation between the lawyers, what do you see your client needs? Who do you think is a good fit for your client for their coach? And for different reasons,
one coach or a two
coach. And if it's or is there a need for, somebody to, speak on behalf of the children? Do we need a child specialist? But, in making those decisions, you're trying to find the right fit for the parties, as far as personality. Would one work better with a man or with a woman? Does it need to be, a psychologist? Can it be an LPC? Which person fits the mold is as important at this stage as any work that the mental health professional is going to do. In the case, if you get the wrong person in there, and I know we always try to give the clients, a name at first, saying, hey, we think this person may be a good fit. They may get into a meeting with their potential coach and they may not gel. All right, well, we need to go to step 2 and figure out who that next possible person is, because if your team doesn't gel, it's going to be a train wreck at some point. And same with the financial neutral, which I think is the next person Virginia was going to talk about.
That's correct. Like Brian was saying, even with the financial neutral as well as the coaches or the mental health professionals, the right person is key to getting the job done, so to speak, and some thought needs to go into that. I think, like Francis and I said the last time, for those of y'all who weren't on the phone call, usually the financial neutral ends up being everybody's favorite. Maybe it's because they're tackling an issue of math and numbers and finances that has a tendency to scare even the bravest of us. And like we said last time, there's only one financial neutral, where in litigation, a lot of times you have 2 financial experts, one for each party. In collaborative, we just use one financial person. And again, that, like Brian was saying, do you need a CPA? Do you
need a forensic? Do you have a business to value? Yeah,
those kind of things.
Financial planner.
Right.
Just,
Yeah. So CFA. So it depends on the situation to determine as well the qualifications of the professional and what might be needed in those circumstances. Again, just like you don't necessarily have to have a whole team meeting. A lot of times there will be a meeting between the parties and the financial neutral, and usually there's one person in the relationship who has more knowledge about the finances, and so the financial neutral will usually ask that person to provide documents and things that they will need to review, and at that time they will have a meeting to go over those things. Sometimes the person who maybe doesn't have as much knowledge may need a separate meeting, maybe just with the financial neutral and that party, but of course the financial neutral needs to clear that with the other party, so no one thinks that somebody's getting special attention or getting information that the other side's not getting. But y'all can imagine sometimes when there's one party that knows everything backwards and forwards, how boring and probably irritated they could probably be if the other party's like, now wait, what? Can you go over that for the 3rd time?
Well, and it also gives that party the opportunity to ask questions they may not have felt comfortable asking during the marriage.
Right.
Well, and the confidentiality issues are a little bit different for a neutral than they are for an aligned professional. I mean, even though we are all sort of first devoted to the process itself and second devoted to our individual clients' individualized needs and interests, and hoping to meld that with the party's stated shared goals. When a neutral is involved, absolutely none of the communication that either party has with them is confidential. And so that's an important thing for everybody to be aware of. We spend a good bit of time in our participation agreement signing meetings, making sure they understand what the bounds of confidentiality are in the collaborative process. So you can tell me something confidential, and I can be bound by that confidentiality, But if it's material to the process and you want me to keep it to myself, then the process breaks down.
Right.
So it is important for people to understand, and that's why you'd have to get permission from both parties for any neutral to meet alone with one party.
Right.
And that neutral then will absolutely send out minutes from that meeting. This is what we discussed. This is, it's always eye-opening with the financial neutral, I've found as well. They will have a meeting where it's typically both parties and both attorneys, and they, will either have, printed out or on a large screen, the financial breakdown of the couple, and with, what the monthly expenses look like, what the, assets of the marriage are, what the debts of the marriage are. And it's always eye-opening, not only for us, to get that much information, but for the parties to see, wow, here's, where the rubber really is hitting the road in our finances. And you have the ability then also to make projections about, okay, if we divvy up the assets one way versus divvying them up another, what's that going to look like in 2 years, 5 years, 10 years, which you don't get in litigation. You don't, have the opportunity to say, if party A receives this account, it's going to last 15 years. Doesn't come into consideration. We're just trying to find a quick way to divide and make it happen. So I think you have the opportunity with a good financial neutral to have a far more fiscally sound outcome than may happen in other realms.
Mm-hmm. And a better overall understanding of what your financial situation is. I think that's pretty much. I think that covers the financial neutral. As far as the attorney is concerned, being an attorney in the collaborative process is a little bit different. You're not sticking to your litigation process of this is what the law says. You're helping your client work through options, and as long as it's not contrary to the law or violate the law in some way, you're open to lots of options and really doing and trying to help them do what's really best to meet the needs of the family as a whole. Go ahead, Brian.
I was just saying, one, I think, good example with that, again, in the matrimonial area, is, college education. Courts can no longer award, or order a party to pay for the post-minority support, including college, of one of their children. But it is absolutely something that the family has to take into consideration, and is one of the major stressors of a family, with high school age, children. So yeah, we can absolutely talk about, what is that going to look like? A judge, you know when you're going to go try a case, a judge isn't going to order it, can't order it, but we can absolutely talk about it with the financial neutral and get some guidance as to what assets are available, and and maybe help have a reality check that, neither one of you are going to be able to afford to, pay fully for your child's education, and that you're going to have to look for financial aid and cross some of those bridges that, may not get addressed otherwise. And so that's where, again, you're not ignoring the law. The law is what it is,
Sure.
But you're absolutely providing the services your clients need.
Absolutely. Also bringing your client back to the participation agreement that we talked about in
Right.
one of our initial webinars. Sometimes they begin acting in ways that are contrary to the participation agreement. So bringing them back in a gentle and kind way, if you can, to remind them of what they signed on the participation agreement, so it doesn't derail the process. And I think Frances also mentioned the confidentiality aspect, so I don't want to beat a dead horse about that. But like she said, the confidentiality aspect with the lawyer is slightly different. Obviously, there's confidentiality and there's the privilege, but like Frances had explained on our last webinar, I think in September, that if you tell us something that we think would be material, you can tell us not to say anything, and we can't say anything. But at that point, we have
process is
done.
the lawyer has to get out of the process. Doesn't mean you can't get another collaborative lawyer though. You
Sure.
just stay in the process.
And that's actually a prickly issue,
Mm-hmm.
because there are sort of two ways to handle that. the lawyer could just get out and say, my grandmother didn't die.
Yeah.
Sort of the noisy withdrawal approach. But in a way, it's not fair to the process, and it's kind of an abusive process for someone to then go to another collaborative lawyer to whom they do not share the information and thereby keep it from.
Because they've learned, oh, if I say this, it's,
yeah,
that it is sticky.
We're not trying to give people ways to jump through loops. Yeah.
Right.
And these confidentiality issues, because they are pretty different from the way lawyers generally look at this issue, pretty different when you're doing collaborative practice. It's probably one of the reasons that collaborative lawyers need to be trained collaborative lawyers, because it is, just for an example of the confidentiality issue, suppose a client tells you in confidence, well, I've got this $50,000 bank account that I opened online that my spouse doesn't know about. Mm-hmm. Well, you're really supposed to disclose that in the collaborative process. And if you don't, there is no collaborative process.
But let me ask you something, because this is actually a really interesting discussion. Let's say you're in a litigated case and somebody tells you that secret. Mm-hmm. What are you going to say? Are you going to say, oh, yeah, I'm going to keep your secret?
Personally, I think you still encourage your client. You tell them, look, they're going to get this information.
Exactly. That's
a well-written interrogatory, a question in a deposition. If they ask about what accounts you have, and I know that you've not, it's perjury. We're not going that direction. So you're still going to advise, but it's not going to be an automatic. Hey, I'm going to go tell them.
Right. That's right.
Right.
Yeah, that's the difference. Yeah. But in terms of how the client is impacted, the truth is coming out. I'm not going to participate in keeping secrets in any process. I mean, I hope that we're all on that page.
And as Virginia was saying, go back to the collaborative agreement. Take the client back and say, look, this is how we do this.
Yeah.
And one option, aside from withdrawing, is having a heart-to-heart with the client and saying, we really have to disclose this, And
that's what generally happens, is that you remind them that it needs to be disclosed. And you also tell them, even if you go into that other paradigm, they're probably going to get this information. So, yeah, you might as well go ahead and let's just figure out the best way to disclose this information and to deal with it. So I think our next slide is, how do you become a collaborative lawyer? And you can probably just put all the little, because I'm probably not going to go in any particular order, but I was going to say that probably the most important thing to communicate to people about this is it's damn hard being collaboratively trained and working in a collaborative manner. It's not like falling off a log. I think some people's mindset is more naturally oriented to collaborative than other people's, and for some people it's easier to learn, but it is a significant paradigm shift, and it's a paradigm shift for the clients, it's a paradigm shift for the mental health professionals, for the financial neutrals, for everybody, and you're kind of the conductor. And so if you haven't made the shift, nobody's going to make the shift.
Conductor, gatekeeper.
Yeah.
Herder of cats. It's all of it.
So this is not the kind of thing that you go to a CLE at Aspen and skip half of it and to go ski or to hang with your family and just show up for an hour of it and then read the material later and feel like you've learned what was there to be taught. This is a hands-on, experiential kind of training process that it's not a one and done either. It's pretty much you go to one and you begin to understand, and then you go to another one and a new level of understanding develops, and then you have a collaborative case or two, and then maybe you realize, you know what, I need some more training.
Right. And things like mediation training, I think is hugely helpful.
Yeah.
There have been seminars on interest-based negotiation that I think are an excellent piece to add to it as well. Anything that helps you start looking beyond just the, what your client wants and getting to the why and getting to how do you actually help them define the why, I think is hugely helpful.
Mm-hmm. So you need to expect a learning curve. You need to allocate time to learn these skills. And another hugely important part of becoming collaborative is to develop a collaborative community, to get to know lawyers and financial people and, mental health professionals with whom you would form teams, to begin to develop a level of trust that is necessary to be able to effectively collaborate. Brian and I, in our first collaborative case, I will never forget this. I was driving into my carport talking to Brian on my cell phone, and Brian and I were yelling at each other.
You got a little heated.
I was like, wait a minute.
That's all right.
We're in the wrong box here. Like,
Yeah.
Why are we yelling at each other? We're not fighting facts here. We're not trying to prove facts.
And in that case, in all fairness, that case wasn't a good one for collaborative. Our learning curve was short and steep, and we hadn't learned how you could tell what's a good case for collaborative, or how to, identify parties that really weren't going to be able to do this, and they sucked us right into their model, and we had to take a step back and go, wait a second, what are we doing? And we were able to get the case resolved. We were able to remind the parties, this is what we're doing, this is how we're doing it.
But we had to remind each other.
We had to remind each other. Yeah.
And so that sort of brings me to, what are the natural skill sets that you need to have to even have any hope of being successful in this? I would say, step one, you got to have some self-awareness. If you yourself have done some therapy in your lifetime, read self-help books, done things that make you aware of who you are and what your limits are and what your triggers are, that's hugely helpful.
Right.
To have read some books and to begin to understand the concepts of transference and countertransference, which is normally the purview of the mental health, gurus in our world. But because that's what happens,
Right.
It's what happens in any paradigm of the practice of law. I'm sure that everyone has had a case where they were trying to talk to the other lawyer and they just felt like the other lawyer was entrenched in a point of view that
Mm-hmm.
did not make sense or seem consistent with who that lawyer was as a person.
Right.
And that's transference. That's when a person takes on the agenda of their client, and that's where the danger zone is.
Right. And not everybody is cut out to do. I mean, it takes the right team members, the right people, the right clients. You can't jam the square peg into the round hole. And we're not by any way saying that other ways of practicing are inferior or bad, or this is just a different method of looking at it. And there are lawyers who are absolutely fabulous litigators that would never be able to do this. There are people who are collaborative in mind who would never be great litigators. There are people that are a good combination of both.
Mm-hmm.
It's figuring out, I think, as Francis said, knowing who you are, what your skill set is or skill sets are, and being able to identify this is something that I really feel I can be successful and help people with.
I think another bullet point I just had is the importance of being able to work on a team. I think most of us as lawyers in the other paradigm are sort of lone wolves. We are used to calling the shots. We've got a relationship with the client. We're not sharing that relationship. We're not sharing the role of being the guide
Mm-hmm.
to the client. And so to begin to work in teams is really a paradigm shift that you need to be ready for. Personally, for me, it's the biggest relief of anything.
It's a good point, and one of the things that happens in collaborative practice is probably astonishing to litigators, but the collaborative lawyers talk to each other's clients.
Yeah.
Often giving the other side's client advice or reiterating something the other lawyer
In
said.
a meeting.
In a meeting, yeah, not
in-
one-on-one, but yeah.
In a collaborative meeting.
Yeah.
And you face it, as lawyers, we're control freaks. we want to be in control of our case. We have a tendency to take on and say, this is my case, and I'm going to do this in my case. And when the client wants to do something else, you say, particularly as a mediator and having heard it said enough times in mediation, you're hurting my case. It's not the lawyer's case, it's the client's case. But our control freak side or our ego-driven side, it's ours, and I want to win it, and I want to do this to win it, not necessarily looking at the final outcome. Yes, I won the case, and I can feel good about my skills when I get done, but what train wreck did I leave at the end of it for the clients to have to clean up? So it's learning to let go of being in control and remembering it's the client's case, not my case.
But one thing too, sometimes the other professionals, because they're used to the lawyer being in that role, though, they kind of almost see you as that. And so until you've had a team that's worked together a bunch, sometimes the lawyers just sort of organically take on their litigation role, so to speak, of being the guide, even though when other people step up, it sure feels nice.
It does. It does.
Anyway.
It's nice to have the right professionals doing their job.
Yeah,
and not having to feel like I slept at a Holiday Inn Express last night and therefore now I'm a counselor.
Getting real colorful here today.
So in addition to those psychological insights about us lawyers that Francis shared a minute ago, just from another perspective too, some of us sort of are naturally born fighters and some of us are not. And some of us, and this is sort of in part where I come from as a collaborative lawyer, some of us are sort of we're problem solvers. Things come to me and I think, well, how can I help fix this? I don't necessarily think, well, let's figure out how to fight. How do I make this better? How do I fix it? If you're a problem solver, if you like to fix things, maybe that's a clue that you could become a collaborative lawyer.
Fair statement.
Brian, you want to talk about how to discuss process options with the client?
Sure.
Do we have any questions, by the way?
Doesn't sound like it at this point. Unlike in any other meeting when a client comes in, we are required under the Collaborative Law Act to discuss all options for handling that case that are available to the client. I personally wish that was across the board, that people who even weren't collaboratively trained had to at least be able to say, this is an option that's out there. I may not be able to help you with it, but here's an alternative. But you have to discuss every option available. So again, while collaborative fits other realms, family law is the realm that it's most often used in, so that's the example I'm going to use. You have to talk with your clients and say, okay, here's what an uncontested divorce looks like. Here's what mediation looks like. Here's what litigation looks like. Here's, mediation with or without attorneys. Here's, what collaborative looks like. And in dealing with that issue of obtaining informed consent, that they know not only what collaborative is about, but what their, other alternatives are to them that are available, so that they can make the right choice for their case. And even if they say, absolutely, we want collaborative, it may not, the lawyers also have a responsibility of saying, yeah, you may not fit, or yes, this is a good case. It very early in the practice, it's very easy to want to oversell collaborative. It's very easy to want to see every case that comes in your door and say, oh my God, you're a great fit for collaborative. Let me tell you all about it. And you end up with the cases like Francis and I were just talking about, where the clients don't really fit for whatever reason. You have to have open discussions with your clients about their level of trust with their spouse. That in and of itself is not always a determinative factor, because you're going to rebuild trust if the process works right. But you need to find out, is there uncontrolled substance abuse? Is there a history of domestic violence? These are areas where collaborative may not be a good fit. I had a couple cases recently where people called me and said, hey, we want to come talk about collaborative. We've seen some information about it. We really think it fits. They've gotten to my office, and as we've talked about it, we realized what they needed was an uncontested divorce. That they were just trying to find a way to get across the finish line. They'd reached all the, agreements that they needed to reach. They just needed some help on how do we finalize it. So you have to, it's not only convincing yourself that the clients are able to do this, but it's also making sure that the clients understand, here's what I'm giving up if I sign this participation agreement, that we're not going to file motions, we're not going to issue subpoenas, we're not going to make the other side sit under oath and answer questions in a deposition. We're going to be transparent. We're going to freely volunteer information. And if that doesn't feel like the right fit, well, here's what we can do in litigation. Or, hey, maybe, collaborative's not the right fit, but maybe you need to hire a good mediator. And you and your spouse, either with or without counsel, sit down and try to hammer this out. So they have to understand their options. They have to have the time to marinate on it and to make the right choice. Nothing is going to be worse than, 6 weeks into a collaborative case, the client comes to you and says, I don't know why you let me do this. You forced this upon me. I can't do this. And the process breaks down and they're stuck in a position of having to start over. So I think it's very, very important to make sure on the front end that you have an open and frank discussion about not only the options, but where your clients are.
Mm-hmm. Yep. Anybody else got any comment about that? I'm really hoping we have some questions.
Well, one of our collaborative professionals here in the Birmingham area, who's not here on this call and is in fact outside the state right now, sometimes argues a little bit more strongly with regard to the requirement that lawyers explain collaborative law to potential clients than Brian has. There is a view out there that every client who comes into an office with a dispute should be told about the collaborative law option, because it is an Alabama statute which provides for a means of resolving a dispute. And
I certainly tell everybody.
Right. But you get lawyers who aren't collaboratively trained, who this client has come in with this, this dispute, and if I tell them about collaborative, well, I'm telling them to go see somebody else. This is the case I want to work on. This is,
just to make us all proud of each other, I have a case going right now where a lawyer filed a complaint. The client said, my wife and I have decided to collaborate. That lawyer referred her client to me for collaboration. And when the participation agreement was signed pursuant to the parties' agreement, she dismissed her case.
Good. How often has that happened?
It's the first time.
Okay.
But, it's 2019. We're making progress.
When collaborative first started becoming a thing in Alabama, there were plenty of lawyers, and I would hear conversations and be, parties of conversations in, the lawyers' lounge, the divorce courts, about how it's unethical, how it doesn't work, how this is, And I thought back to the mid-90s, with mediation, and hearing lawyers say the same thing. This will never work. This isn't ethical. This is,
mediation.
Mediation, yeah. Mm-hmm. That this, it's something new. So, lawyers who haven't gotten the training, or who, feel differently about whether or not collaboration should be, are quick to, poo-poo the idea of it. And I think that's unfair to, to the clients to, have somebody come and say, oh, this is a bunch of bunk. This, it's touchy-feely. It's kumbaya land. This isn't what you need. You need to do, traditional, we'll file a complaint, serve your spouse, have serve them with discovery, have a temporary hearing, and that's how this gets done.
Or why can't we just mediate your case?
Yeah.
Even to suggest a better alternative, but that is not what they ask for, or not the best for them.
Clients, don't know their alternatives when they come in, and I've had plenty of clients who, when I've gotten done with the conversation on the options that are available, go, I didn't realize I had choices. this has been helpful, and it may be that they don't choose collaborative as the route. It may be that they say, they'd rather have, just handle as an uncontested divorce or whatever else. But the fact that, I came in with questions because I did not know what steps were available to me, or what my options were. If we provided at least that much information, then they've made the informed choice themselves. And I think that's a big part of our job as attorneys, is to let our clients know what options they have to resolve their conflict.
And just to clarify, how is this ethical? This new way of doing things. I think it's important to point out that this is a limited scope representation. So that's really pretty important. You really need to have a limited scope engagement agreement with your client, and you really need to discuss with your client as part of the whole global informed consent process that your role is limited. You will not be their litigation attorney. You cannot be their litigation attorney.
Right.
Right. And to be a little lawyer geeky about it, that's Rule 1.2
Thank you.
C, which provides for a limited scope of the Alabama Rules of Professional Conduct, which provides for limited scope representation. And this actually is the reason that we
Can do this.
Among others, it's the reason we can do this. It's also the rule that requires informed consent, because with any limited scope representation, that rule does, it's 1.2C1, the client's informed consent must be confirmed in writing. So not only is that informed consent an aspect of the collaborative process that we're taught anyway, it's also in the limited scope rule.
Do we have questions? And a question?
If you have a question for our panelists, if you'll go ahead and just state your name and ask your question, we'd appreciate it.
You'll have to unmute to ask your question and then mute back, I think.
Yes, and I've
Right.
unmuted everyone on my end, so you might be talking right now to your phone. So please, if you do have a question, if you'll unmute your phone. While we're waiting for questions to come, I'd like to ask the panelists, do you use a standardized limited scope representation agreement, or do you each have something different that you use?
I don't know what you use. I know what I have. I can't remember where I got it either.
Yeah, I think usually we have a different retainer agreement, for collaborative versus other representations that spells out all of this. But then we also, when we file pleadings, we usually file the
Limited
the
scope
scope
notice
of appearance, that the form that the bar has created, so that it's clear. And then we also, I think we're all very careful to put on any of the pleadings that we end up filing, because at the end of the day, the only way a divorce gets granted is to file a complaint for divorce and the supporting documents as an uncontested divorce. Anything that I know that I sign, I always have collaborative counsel listed under there, along with having, the limited scope notice of appearance filed, so that there's no question if, somebody has to modify something down the road and looks at it, that they see how this process worked and what role I played in the court
there
record.
was a point in time when Birmingham Collaborative Alliance spent a lot of time in one of the committees, developing a whole bank of forms.
Yes.
And I would be willing to bet that there is a limited scope engagement agreement in that bank of forms.
I think there is. I think that's where I originated I think that's what I took to make my, yeah.
Yeah.
That's
So
what
if
I
anybody
plagiarized.
wants one, we can probably dig up a form.
Sure.
Oh, I mean,
To let everyone know, the last page of your slide has the contact information for our presenters today. We do have a question that has come up, and Matthew Brown is asking, can this only be used in family law?
No, it's applicable in any area of law. It's a limited scope form of representation that could be used in any form of law where the two parties to the conflict hire collaborative professionals and want to engage in it. I think the reality is that family law is the place where collaborative originated, and it is the place where the most traction has been achieved in application of the process. I think that in talking to some of the sort of national players who really worked hard to try to pursue civil collaborative, there's been some recognition that the carrots and sticks that make it work effectively in the family law arena, like the fact that people don't just divorce each other because they're divorcing. If you have children, you're continuing to be bound into a relationship for, the rest of your children's lives. And so that creates an incentive to be civil and respectful and also to protect your children. So there's incentive relative to the application of this process in the family context. I think, probate is an area where people talk about the application, and in my limited exposure to the probate world, if I think that working in family law is sometimes like being downed by an octopus, then I would say probate is like being downed by 10, because you've got so many family members and interested parties and potential, areas of conflict. It would be hard to assemble a team big enough to handle all that, and it would seem cumbersome. So, I don't know. I mean, all of that said, it's definitely applicable, and I know that there are areas like in North Carolina, they've done some work in the med-mal field with collaborative, which is just a hugely promising idea.
Anywhere where there's a relationship you want to protect on the other side. So from matrimonial side, obviously you're looking at people who are going to have to co-parent, for example. But I think there's closely held business is exactly where it's going. That a business dispute, whether it's the dissolution of a business or two businesses where they've had some contractual issues that have gone south on them. You may not have the mental health side as much, but you might, particularly a closely held business. But a neutral financial person looking at the contract, you want to preserve this and potentially work together again on the other end of this case. I think is absolute fit for collaborative.
It's a very good point. If you skip down to slide 13, there's a slide that identifies the Global Collaborative Law Council. That's sort of the civil side of collaborative law primarily, and there's a good bit of information on their website. And just to follow up on what Brian was saying, I know that some people associated with the Harvard Negotiation Project in the Boston area have worked with high-tech firms with regard to disputes within the ownership structure of a sort of nascent technology firm using collaborative law techniques, if not specifically collaborative law, in order to try to preserve a business that potentially could be a $100 million business sometime. But if you blow it up because the personalities are in conflict early on, that's kind of a stupid thing to do. So there are actually, and if somebody wants to contact me, I can refer you to a couple of very good books written by some folks up there who are in that field. It's also useful for business disputes, such as disputes between a general contractor and a subcontractor, or a developer and a general contractor. Some of those folks have done business together for years and have made lots of money, and then they get in a dispute and they litigate and they blow up the relationship, which maybe doesn't make sense because they could have made a lot more money out of the relationship. So collaborative law can have a role in those kinds of disputes too.
Thank you. We have another question from Mary McGowan asks, can you give us an example of when mediation appears to be more appropriate than collaboration?
If you have people who can't communicate directly.
Right, where you need that neutral, person working between them. Absolutely. Also, there may be cost issues in this, and we did not talk about cost, but it may be that from a cost effectiveness standpoint, mediation may be more cost effective for the parties than than going through a full-blown collaborative process.
It's kind of like, it's sort of like a Maslow's hierarchy kind of analysis. The cases that are best suited for collaborative are really the ones with the most complicated issues, right?
Right.
So if you have, you know, a family with a special needs child, or a small business, or a, you know, complicated financial structure,
sure.
you know, but if a case is fairly simple and straightforward, it's a little bit overkill.
True.
You know, I mean, it's certainly the client's choice.
Absolutely.
But I think over time, as we've gotten less zealous about wanting to collaborate and a little more, you know, sort of discerning about it, we've recognized that there are a lot of times when it just seems like overkill. Like, to assemble a team just to decide how to sell your house doesn't make sense. But if there's a lot of conflict around it, you might need a mediator to help broker the compromise about the issue.
Right.
Does that make sense?
Yes. Are there any more questions for our panel? Well, panel, I'll give you the opportunity to make some closing remarks before we end the webinar.
Do you have any closing remarks, Brian?
No, but it was on the slides, and everybody should have been presented a copy. There are contact information is all there. There are contact or website information for several organizations that can provide more information and training. And everybody on this call is happy to answer questions or discuss further with anybody who may have questions that they didn't feel comfortable asking as part of the webinar.
I also wanted to refer people, someone asked about civil collaborative law. There's a list of publications toward the end of the series of slides as well. I think it's slide 14 and following, where there are actually many books listed. But the first three are all on civil collaborative law, written by Sherry Abney, a lawyer in Texas, who's one of the founders of the GCLC that I mentioned a minute ago.
Cool deal.
All right.
Well, y'all feel free to reach out and let us know if you have any questions. And if anybody has reached out to me in the past and I have not responded, please forgive me. I have just gotten through a crazy season, so reach out again.
All right. Well, thank you, Virginia, Brian, and Stephen, and Francis. Y'all have done a great job, and we really appreciate you taking the time to put on these sessions to help us learn more about the collaborative practice of law. I invite everyone to visit the Alabama Center for Dispute Resolution's website and Facebook pages for more training opportunities. Our next free webinar is set for December 6th, where the discussion continues with informed consent and civil collaboration, and that will get you 60 minutes of ethics CLE. We hope you will join us. Please remember to complete the program evaluation on SurveyMonkey. Here's the code you'll need to enter on the survey. It's 3897. That code again is 3897. And again, please visit the Alabama Center for Dispute Resolution website for more training opportunities. We will be offering, as part of Celebrate Pro Bono Week and ABA Mediation Week, I should say Celebrate Pro Bono Month, and the ABA Mediation Week, a free 90-minute CLE in Birmingham on October 30th at the law firm of Cerroti and Permit. We're very grateful to Cerroti and Permit for hosting it, and they're also providing a complimentary lunch. Registration is limited to the first 50 registrants, and that is also being co-sponsored by the Dispute Resolution section of the Alabama State Bar. The recording of today's webinar will be posted on the Center's website, and thank you again for attending, and this will conclude our webinar. Hope to see you in December.